The South Dakota Property Rights and Local Control Alliance, SDPRLCA, thanks you for participating in our 2026 Attorney General Candidate Video Survey. As a nonpartisan grassroots organization, SDPRLCA is dedicated to protecting private property rights and maintaining local authority. Following the 2024 general election, where 65 of 66 South Dakota counties voted no on Referred Law 21, voters are eager to hear where the Attorney General candidates stand on these core issues. So the ground rules for the interview, we'll have you introduce yourself for a minute and a half, and then we've got 5 questions, and we'll shoot for 2 minutes answer per question, and then a closing statement of 2 minutes where you can just give whatever information you would like, and then you're free to go. All 5 questions will focus specifically on property rights and local control. The candidates receive a specific set of 6 questions in advance and will respond to 5 of the questions. And the recordings will be posted on our Facebook page, YouTube channel, and website. So, Mr. Russell, so the program is to answer 5 of the 6 questions. Which question is it that you're not answering, so I don't ask you that one?
I think number 4.
Okay, very good. The one about eminent domain. Okay, very good.
Yeah, and I may cover it. I may cover it elsewhere.
Okay, that is just fine. That's just fine. So, if you want to, go ahead and introduce yourself.
So my name is Lance Russell, and I am the Fall River and Oglala Lakota County State's Attorney. I was elected 25 years ago as State's Attorney for those 2 counties. And in the interim, or in the middle of that, I spent 12 years in the legislature, 8 in the House, 4 in the Senate. And my time in the Senate, I was chairman of the Judiciary Committee. When I first became the state's attorney, we had some turmoil over property rights in Fall River County vis-a-vis the national grasslands and the mismanagement thereof. I essentially went to war with the federal government. We got 3 plan amendments, essentially victories, and saved the ranchers quite a bit of money from all the way from Edgemont to Lemon. I look forward to answering your questions, and if you ever want to call me, please do so if you want further information. And you're also free to contact the ranchers in my area if you want to confirm anything that you're going to hear tonight.
Okay, well, very good. Thank you, Mr. Russell. So the first question is on civil asset forfeiture. In South Dakota, civil asset forfeiture law allows the state to permanently seize a citizen's cash or property without a criminal conviction, and 100% of those proceeds go directly into the Attorney General's own drug control fund. As Attorney General, will you protect our constitutional property rights and support reforming state law to require a criminal conviction before the government can permanently take a citizen's property?
The answer is yes. I do believe that a criminal conviction should be the benchmark before there's any kind of a forfeiture proceeding. It's basic due process in my mind. As it relates to the control fund, I was around when Barnett changed it. It used to be that the forfeitures would be done locally, and the local state's attorney and law enforcement would divvy up the money from the forfeitures for their own jurisdiction. Now you have to beg, borrow, or steal from the Attorney General, and I think that we need to go back to the way it originally was.
Okay. Well, thank you. Question number 2 is on hand counting at the county level. Constitutional conservatives believe local government governs best. State law explicitly says counties may adopt or abandon automatic tabulating systems, yet there is a fierce debate over who has final authority. As Attorney General, will you issue an official opinion confirming that state law allows each individual county to decide for itself whether to use electronic tabulators, hand-counted paper ballots, or both?
I will preface my answer with the fact that the county commissioners in Fall River County asked me if they could do a hand count in a primary a couple of years ago. We did a hand count of everything in the county in the primary. The issue and why it's a little bit dicey is the federal government has a certain leverage over federal elections. And in that particular situation, we didn't have a qualifying federal election, so we could do the hand count. What I will tell you is that I will work with our congressional folks to make some changes at the federal level along the lines of what President Trump wants in order to facilitate hand counting and we'll go back to where we elect people on election day. It doesn't take 60 days prior to get the election done. It ran fine. We hand counted for 100 years, and there's no reason we can't do it again.
Okay, very good. The third question, right to petition. South Dakota law guarantees county residents the right to petition their local commissions to put measures to a public vote. However, several county commissions and state's attorneys have declined to place various citizen petitions on the ballot, advising that the topics involve administrative decisions rather than legislative policy. As Attorney General, how do you interpret the legal boundary between the constitutional right of citizens to petition and a county's administrative authority?
This is an interesting question that I've actually dealt with. We put something on the ballot in Fall River County that was initiated by a petition. The South Dakota Supreme Court within the last year ruled adversely to your position. What needs to happen, in my estimation, is that we need to retool the statute, one, to provide stronger definitions of legislative actions versus administrative actions. It's too nebulous, number one. And number two, provide that the local district attorney would have to, if he and the county commission are going to deny a petition to be placed upon the ballot, that the state's attorney and the county commission would have to seek a declaratory judgment from a judge to determine if the subject matter or the end result of the petition would violate the law. Right now, they're just saying, well, it's my opinion that you're violating the law with this petition. But what I'm saying is that we need to have an extra step in there that has the state's attorney on, it would become his burden to go to court to vindicate his position. And I would pursue legislation to that effect.
Okay, very good. Question number 4. Lawyers' special rights, qualified immunity. Constitutional conservatives believe in equal justice under the law, meaning the government should never grant special privileges or immunities to a preferred class of citizens. Yet, during the 2024 session, House Bill 1023 was signed into law, granting broad civil immunity to the mandatory State Bar of South Dakota and its agents. As Attorney General and as a member of that very bar, how do you justify giving lawyers and their regulatory board a shield from liability that regular South Dakota small business owners do not enjoy? And will you support repealing these special protections?
The answer is yes, I would support repealing it. I do not, but I looked up that bill. I would have never voted for it. You are 100% correct. If there's any class of people that can defend themselves without the need for qualified immunity for the actions of the bar, it would be lawyers themselves. I still couldn't believe it when I read it that actually passed. So yes, I would be interested in repealing that law.
Okay, very good. And question number 5, primary instead of convention. The current convention system allows delegates and precinct committee members to vet and nominate statewide candidates. However, there are ongoing debates about whether moving these nominations to a public primary would increase broader voter participation. If legislation is introduced in Pierre to shift the nomination of statewide offices, like Attorney General, from the party convention to a primary election, what will be your official position on that bill, and how do you view the balance of power between convention delegates and the general primary electorate?
I will publicly come out against it if I'm Attorney General and they try and take any more positions away from the convention. The reason why I was the executive director of the state Republican Party at one time, it must have been in 94, 95, somewhere in there. And the party, the reason why we have always done it this way in South Dakota is because of the expense associated with having everyone on the same ballot in a primary, all these down ticket races. It makes it very expensive, number one. But number two, and more importantly, in my mind, the reason why we have done this historically is to keep the big corporations and the big money from being able to essentially influence all of these races. When you truly have a grassroots operation like we do in the party, and it isn't about money. I'm only going to probably spend $20,000 running for Attorney General. And I believe that that's a good thing. And the reason why I say that is because this process is more about persuading people across the state that you have their best interest at heart. And it allows the most educated people in the process to make the decision rather than people going in that have no idea who's even named on the ballot for that primary. So yes, I will publicly oppose it if I'm elected Attorney General.
Very good, very good. That seems like a very astute answer. So that is our 5 questions. In closing, as we head toward the South Dakota GOP convention and election, it's vital that voters know how to reach you. For our final 2 minutes, please let the folks know how they can contact you directly, where they can learn more about you, and why you are the candidate that should earn their vote.
I encourage any of you to stay in contact with me. You have this cell phone, but I'm also going to give you my private business address, and that is 605-745-3228. And Lance Russell, or Lance_Russell with 2 S's and L's at yahoo.com is my email. I encourage you to reach out to me. But even more importantly, if you, I think that the most important verification process that you have is to contact the landowners in my area. For instance, the head of the Indian Grazing Association, the head of the Cottonwood Grazing Association at Edgemont, and the head of the Pioneer Grazing Association at Ulrich. They will tell you that I have vociferously fought for landowners for the past 25 years. When their livelihoods were at stake in Fall River County, they wanted to introduce the black-footed ferret in Fall River County and essentially turn the Smithwick area into a Kanata Basin. I dug in. I went to work with the grazing associations. Like I had previously said, we won 3 amendments on the grasslands management plan. It's not easy to get that accomplished. and we fought with them and cajoled, and we got buffer zones for the landowners. We got the state to pay for the poisoning in the state prairie dog plan as part of it. But if you talk to the ranchers in my area, I would encourage that, and hopefully some of you will in fact reach out and verify what I tell you. I thank you for the opportunity to speak with you tonight. I look forward to working with you in the future, and I will have an open door policy when I am the Attorney General, if I'm so lucky to be so.